I encourage you to take advantage of us. We answer questions. What we'd like to do is try to give you answers before situations become a problem when it comes to freedom of information. When we do talks like this, or when we answer questions on the phone or answer emails, it's not a binding order or a command. It's just advice. I've just finished 20 years at the FOI Commission. I'm kind of staggered by that number, but time does fly. And I'm not an attorney, just to be clear on that. So I'm not giving you legal advice. I'm base my advice on listening to the commissioners, listening to my colleagues, some of whom are attorneys, and also, frankly, from my life. I was, many of you I know are volunteers, members of boards in town. I was on a board for 10 years. I was the chairman for the last 5 in my town. Got off and then got sucked back in. I was actually on the board of selectmen for 2 years, and then left that board, not voluntarily. It's full disclosure, but that's the way it goes sometimes. And now I just got asked to be on another board, compensation review. So I know what it's like to be a volunteer and to try to do good for your town. And sometimes it can be difficult juggling your real life and your volunteer life. And you didn't necessarily sign up for this freedom of information stuff, but you have to understand that it comes with the territory. It's something that we all need to know when we're on a board or a commission, and we have to have at least some knowledge of it so that we're not tripped up, so that the hard work we're doing doesn't get undermined by a violation of the law, many of which are unintentional. I use the word law, and that's really important that we recognize that this is the law in the state of Connecticut. It's not just some great idea. It's not just some lofty thought. It's the law. It's in section 1-200 forward, and the law is actually 46 years old. It was Ella Grasso's brainchild when she ran for governor for the first time. And if you do the math, 46 years ago puts us right smack in the middle of Watergate. You had a country that was in turmoil, a country that was beside itself with government behind closed doors, secret government. And Ella was in Congress when Watergate exploded all around us. And she said, if I run for governor and get elected, one of the first things I'm going to do is make sure we create some sort of an open government law. And as you know, she ran and won in 1974. And that literally is one of the first things she did in 1975, was put forward this concept of an open government law. And she felt it was really important, obviously. And then she said, this is so important, I will see to it that this law is approved unanimously by our legislature. Now, I want you to ponder that for a second. I don't know if we have any legislators or former legislators in the audience. Think about guaranteeing a unanimous vote. I mean, even your RTM, think about guaranteeing a unanimous vote on anything, let alone something as powerful as the Freedom of Information Act. Well, she guaranteed it and she got it. I've seen a video. There was not a single no vote in the House, not a single no vote in the Senate. This law was approved unanimously. It was signed with a great flourish. Now, other than being indicative of how important it was, it also sort of gives us some insight as to why we're here tonight. We have these discussions, we do these workshops all over the state, not to beat you up, but to give you the tools to work with this Freedom of Information Act, because to get to the point where everybody voted yes, if you're aware of the legislative process, there had to be a lot of negotiation, a lot of back and forth, a lot of, well, I like this concept, but not this wording, and I like this and I don't like that. And you've got a law that's based on a simple, easy concept, open government, transparent government. But then when you try to read it, this is where I ask people for a show of hands, which we can't do, but I suspect many of you have looked at it or tried to read at least a portion of it, and sometimes your eyes roll right to the back of your head. You say, what, wait a minute, what? It's about open government, but it's because this law has left gray areas in there so that they could get it, I think, so that everybody could agree to get it passed, but it leaves it open to interpretation. Those of us who are on the front line have to be able to interpret it. And we look at it, we say, gee, should we be in executive session? Is this a record we should withhold? This is a record we should give out. And these are decisions sometimes we have to make on the fly. And so to do that and do it correctly and not get hung up with a difficult FOI situation, you have to have the tools to work with, which is why which brings us back to why we're here tonight. Because if you do something just sort of willy-nilly under freedom of information, the person on the other side of the issue can file a complaint with the FOI Commission. One of the things this law did was create literally one of the kind. There are no other FOI commissions like ours anywhere in the country. If you believe you've been denied the access, the rights that the FOI Act gives you, you file a complaint with the FOI Commission, and the commission adjudicates that complaint and says, well, Fairfield, you were correct on that one. You were properly in executive session, or Fairfield, you were wrong. Don't do it again. So you want to avoid going up there, and to do that, you want to be able to make the right calls when it comes to freedom of information. Now, you may have heard me say, freedom of access. It's called freedom of information. That's a better name. That's a better sounding title for this law. But it's really about access to two basic things: access to public meetings, access to public records. I'm going to talk mostly tonight about the meetings provisions in the time that I have, because many of you are on boards and commissions or on your RTM. I'll hit briefly on the records provisions, but as Jeff said, if questions come up as I'm talking, I want you to stop. I want you to ask, because sometimes answering your questions and making you more comfortable with some issues is far more important than some of the other things that we might get into. So when we talk about meetings, I don't read a lot of definitions, but let me read just the definition of a meeting in the Freedom of Information Act. Meeting means any hearing or other proceeding of a public agency, any convening or assembly of a quorum of a multi-member public agency, and any communication by or to a quorum of a multi-member public agency, whether in person or by means of electronic equipment, to discuss or act upon a matter over which the public agency has supervision, control, jurisdiction, or advisory power. The bottom line there, folks, is that when a board or commission gathers to do its work in any way, shape, or form, it's defined as a meeting by law in the state of Connecticut. You want to make sure the meeting is properly noticed, that it's open to the public, and there are minutes of that meeting when the meeting is concluded. Tom, well, it's budget season. Can a bunch of us get together just to go over some stuff preliminarily before we work? No, you can't. The law says that if you've gathered to do your work and you're on a board of finance, that's a meeting. I got an idea. Let's form a subcommittee. That's not the full board. Then we don't have to, get wrapped up in freedom of information. Also not true. When you read the definition of a public agency, which is the umbrella under which all of us fall with freedom of information, the definition has a phrase in there that says, including any committee of or created by any such office. So you've got a 12-member board and you form even a 2-member subcommittee, an official subcommittee. That subcommittee becomes a public agency unto itself and needs to follow the law the same way. Now I'm going to just go a little bit off track here, because we're in a situation for the last year, and I don't know about you guys, but I can't believe that it's been a year already. We shut down our office. I think it's like 10 days. In 10 days, it'll be a year that we had to shut it down. And we've only been going back, partially. And I know many of you are working from home and remotely and Zooming and WebEx and all that. But when that happened, the governor issued an executive order, which allowed us to expand how we held our public meetings. We are allowed to do it virtually. So it used to be you had to have a central location. It was now, just as a by the way, here's some hot tips for you. There are pieces of legislation in the legislature right now, one put forward by the governor, which may codify some of this, but right now this is only the executive order. It allows us to meet virtually. It allows us to meet virtually, and it allows us to not be in a central location. But when you're doing that, you have an agenda, you post the agenda. The agenda has a link on it with the, in your case, you guys use WebEx, we use Teams, Zoom, whatever it is with that link, because the key part of the governor's executive order is that the people have real-time access. So they link in, they can watch your meeting in action while you're going forward. So you have to, again, it's that real-time access that's so critical. If you have the meeting in person, there's no requirement right now that you also record it like that. But if it's a virtual meeting, not only do you have to provide that real-time access, you have to record it, and you have to make the recording available to the citizens of your town and actually of any citizens who want to take a look at that meeting down the road. But just to back up for a second, we go to the idea that you have these meetings, and the key is to make sure you do your work in public. That's what the law requires. The law talks to us about three different kinds of meetings: a regular meeting, special meeting, an emergency meeting. Regular meeting is a meeting that you have per schedule that you put together every year. We meet on the first and third Tuesday, the second and fourth Wednesday, 7 o'clock town hall. Again, in the good old days, 7 o'clock town hall, or 7 o'clock via whatever platform you're using. And that becomes your regular meeting slot, your regular meeting time. The special meeting is a meeting that you have when you're not scheduled to meet. Now, a lot of people see that word special and they say, we can't do this or we can't do that. That's not accurate. You can do anything you need to do at a special meeting. What makes it special is that it's not at your regular place and time. Here's the key. For both of those meetings, you need to prepare an agenda. I suspect some of you are involved in that. You prepare a complete agenda that's as specific as possible. You need to have that agenda available at least 24 hours in advance in your board's office, if there is one, in the town clerk's office as well. And again, during pandemic time, it has to be on the website with that link to your virtual platform. Here's the difference between the regular and the special meeting. At a regular meeting, should something arise that's not on that agenda, you can add it to that agenda by a 2/3 vote of those of you who are present and voting. Madam Chairman, I move that we add this topic X to the agenda. It's not on there. We need to talk about it. Somebody seconds it. If 2/3 of you vote to do it, you can add it to the agenda. At a special meeting, you cannot add anything to the agenda. That's the critical difference between the two. So if you have a special meeting, again, a meeting that's not at your regular place and time, and there's something not on the agenda, you can't add anything. So I don't know about you, but when I prepare an agenda, I use items like other business, new business, old business. That's not a great item when it comes to specificity, but at least at a regular meeting, the chairman can say, is there any other business? And you can bring something up and vote to add it. But at a special meeting, you can't. So if there's nothing specified under other business or old business, you better take it off, because you can't do anything with that item. You can't say, okay, old business, because if it's not specified, you're not supposed to talk about it. Third kind of meeting, the emergency meeting. Folks, it's a meeting that I really discourage boards and commissions from using. Emergency meeting is an unnoticed meeting. And the problem with it is that what you and I think might rise to the level of an emergency might not. The law sets the bar really high because it's an unnoticed meeting. And the best example I have, it comes with some of these holidays that we have. Martin Luther King's birthday, Veterans Day, sometimes Columbus Day. People forget that those are holidays, and I'll get a call like this. And Martin Luther King's birthday was, last 2 months ago now. Call comes every year. Tom, I've got a problem. What's the problem? A regular meeting is tonight, Tuesday night. I always bring that agenda into town hall on Monday. I always make it available. I forgot we were closed. I forgot it was a holiday. So I brought it in this morning. Is that okay? This year they sent it in because town hall was closed, but you get the idea. The answer is no, it's not okay. It's got to be available at least 24 hours in advance. Well, we've got way too much to do. I'm going to call it an emergency meeting tonight. We're going to meet tonight. My advice at that point is don't do it. Oops, I forgot is not an emergency. In our minds, in our non-legal minds, yeah, this is when we're supposed to meet. We got to go forward. If we don't, we're going to get way behind. I get all that, but the law says you can't. So you want to make sure that if you have a situation where you're going to meet without notice, it's a true emergency. People need to be taken out of harm's way. One of the boards I was on was the Board of Education. And a couple winters ago, when it seemed like it snowed 3 feet every other day, we looked up at some of the roofs of the school and we said, uh-oh. And we had to meet that morning to move some money around to make sure that we could hire somebody quickly to get the snow off the roof so that we didn't have a catastrophe on our hands. That's the kind of thing that rises to the level of an emergency. If you ever have a situation like that, again, if you are able to avoid it, please do. It's just better that way. But you meet You talk about only the emergency issue, and within 72 hours, create minutes that reflect what the emergency was, who was there, and what you did about it. As you know, I'm beating the drums here to make sure your meetings are open to the public. I don't know if Fairfield has had trouble with people interrupting their meetings. The people who use Zoom call it Zoom bombing. Have you had any of that? People that when we first started doing this back, a year ago, many calls came in, especially in the beginning, from boards that were having their meetings interrupted by people with no interest in what was going on, screaming, yelling, racial epithets, curses, insulting board members. And these were people from, other towns, out of town. If that's ever a problem for you, it becomes a conundrum because you can't clear the room. So you have to set up something whereby you've got security. You still have an open meeting for anybody who wants to come, but you have a way of sort of funneling those people out or muting those meetings. I'll share a little story with you. Has anybody heard of? I suspect you've heard of Zoom bombing if you've seen some of the stuff. So it happened to me. I was doing a workshop like this with a much smaller group. It was a citizens group in Enfield, and all of a sudden the screen went black, and there was this very loud music. For lack of a better definition, I'll call it Latin music. This very loud music came on, then the lights came back on, and the strippers paraded across the screen. So there I am talking about freedom of information, and here come the strippers. Let me just say they left very little to the imagination. But if that ever happens to you, you got to keep your calm and try, I know Jeff has the mute button there, but it can happen. If that becomes an issue, find a way to get them out and get your meeting going. You still have a right to run an orderly meeting, even if it's open to the public. One of the things that the FOIA Act does not do, it does not guarantee anybody the right to speak at a public meeting. And that's constantly an issue. People call up all the time and they say they wouldn't let me speak. I wanted to talk. It's budget season. I really want to, public speaking is something that the board allows people to do, but it's not something that you have to do. Now we all do. I mean, let's face it, if you're on a board, if you've been on a board for any length of time, you usually have public comment. Some boards have, two public comment portions of the meeting. But how long people speak, when they speak, if they speak on a specific topic, those are the sort of things that you're allowed to control. I mean, if you say, look, we're not talking about that tonight, if you have public comment on that, save it for the next meet. You have that kind of control. Now, this doesn't necessarily jive with, certain things. In certain boards have it in their bylaws and their their town charters and things like that. But under freedom of information, public speaking is in the hands of the board, and it's not something that you're entitled to. Now, again, going back to, COVID world that we're in now, people get on and they say, well, I can't speak, but I'm going to send them a letter. And I want them to read that letter at the meeting. Now, again, we can argue good policy. We can argue, what makes sense from a, good open government, but that's not required. That would be the same as public speaking, and the board would have a right to say, I'm going to read it, I'm going to summarize it, I'm not going to read it. It becomes a public record, and it's something that anybody could see or read on their own, but the board's just not required to do that. So again, you want to make sure that you've got that control so that you can get your work done, and at the same time you're open and so that people can watch you in action, but not necessarily participate in the meeting if you don't want them to. So I'm preaching open government, accessibility, and as most of you probably know, there's a couple paths that boards can go down to exclude the public. One of them is executive session. You've all probably heard of it. You may probably have been involved in some of them. There are 5 specific reasons for an executive session in the FOIA Act. A personnel matter, pending claims or pending litigation, a security matter, a real estate transaction. You are a police commission and you are looking to build a satellite police station somewhere else in town. You need property, you need a building, you need to look around. You find a building that you want to lease. Well, you could have the discussions, the negotiations with the owner of the building over the lease terms behind closed doors. The law says that you wouldn't have to have that negotiation in public. It's something that you're allowed to do, hypothetically. Oh, gee, the town's willing to pay that much. Let's offer them our building. Those kinds of things. You could have those kinds of conversations behind closed doors. The fifth reason for an executive session, it's something of a catch-all. It allows a board or commission to have a conversation about a document or documents that it believes are exempt from disclosure. Now, if we had a longer period, we could go through a lot of the documents, exemptions, and things like that. Those of you who are on boards can get help from staff when it comes to, gee, do we or don't we? Let me give you one example. You're on a board that puts a project out to bid. You're responsible for those bids. There's an exemption in the FOIA Act, Section 1-210B24, that allows a board or commission to withhold the content of bid packages until it's signed a contract. So the bids come in, you're saying, you know what, we're not going to share this with anybody. We want to look them over. Go on into executive session. You look over the different bid packages, and then you come out and vote on them. At that point, they become public. But when you want to study them, review them, look them over, you can do that behind closed doors. Another example might be you ask your attorney for a written legal opinion. You, the board, are the client. So the letter is covered by the written legal opinion is covered by the attorney-client privilege. It's not anything you're going to share with the rest of the world. You go into executive session to talk about the legal advice that you've gotten from your attorney. Those are just a couple of examples. That fifth reason for executive session is a little broader because there's so many different records that you could conceivably talk about behind closed doors. Now back to the top, the personnel executive session. Folks, if you're going to have an executive session about a personnel matter, lesson number one, do not say on your agenda and in your motion, executive session personnel or executive session personnel matter. The courts have been very rigid, very strict on that. They want more. Now, they don't necessarily want you to name the individual. I'll give you an example. I had a conversation with the town of Colchester earlier today. And they've got a situation where they're going to talk about potential, I want to say, dispute over a heart and hypertension situation. They want to talk about their strategy behind closed doors. So they want to talk about it, and they're saying, well, is that a legal matter or is that a personnel matter? Well, I said, if you're talking about the employment of the officer, you'd have to say discussion of the performance of a police officer. You don't necessarily have to name the person. Discussion of the performance. Now, in some cases, let's face it, there's only one. Because the superintendent of schools, a police chief, a town manager, there's only one. So you might as well name the individual. But just don't stop short with executive session personnel. Executive session personnel matter. Executive session, discussion of the performance of a firefighter is okay. Discussion of the performance of a police officer, that's okay. And then once you sort of set that, you need to give the person notice. The person needs to be told in advance that he or she is going to be talked about in an executive session. That individual then has the right to come forward and say, no, wait a minute. I don't want an executive session. I want that discussion to be held in public for everybody to hear. And if the person does that, you cannot go into executive session. I wanted to stop for a second, make sure that's clear. So the person has the right to demand that it be done in public. Where many people get hung up is they think, well, wait a minute, they're going to talk about me. I should be able to be in the room. That is not a right that's guaranteed by the law. Whether the person's invited into the room is entirely up to the board. So the board typically will invite people in, but it's not required to. So once the individual waives that right to a public airing, the person can be invited in or not invited in, depending on what the board decides to do. Now, the executive session for pending claims and pending litigation, and I mentioned that heart and hypertension situation, they were going to go in to talk about their strategy, not about the individual's performance. So it wasn't a personnel executive session, it was about legal strategy. So I said, you would want to word it this way: executive session discussion of legal strategy pertaining to a pending claim about an employee. Again, you've got to give more than just legal. you have to do more, but you don't necessarily have to reveal what the case is in case putting that on the table might negatively impact your position. You can be a little artful with some of these motions. You have to give enough information so that people know what's going on, but not necessarily tip your hand. And then the executive session for security matter is one that never really used to come up at all. And then around the end of 2012, sadly, when Sandy Hook happened, it became one that's been more and more prevalent. A lot with boards of education to go in to talk about resource officers, deployment of resource officers, bulletproof glass, alarm system, something that many of us, maybe most of us on this call, never had to worry about when we went to school. But now it's become a reality, and the idea would be they could go into executive session to talk about these steps that they're going to take, because they, on the off chance that the wrong people are sitting in the audience listening, you wouldn't want to be giving away your secrets as to what the executive session is going to be. Remember, folks, that an executive session is not something that sits out on an island. It's part of a regularly noticed meeting. So even if you're at a meeting, you're going to a meeting and the only item is an executive session item, you need to open in public, you convene the meeting, someone needs to make a motion to go into executive session, again, citing specifically the reason. You need a 2/3 vote to go into executive session. And those of you who are present and voting, you go in, you discuss, you can talk as long as you want. That's not a problem. You have your discussion. And then when the discussion is over, you must come out to vote. Please do not ever, ever, ever take action behind closed doors. The law is very strict on that. It wants every vote to be recorded. Every set of minutes needs to reflect precisely who voted for what or for whom. The minutes also need to reflect who went into the executive session. So if you are inviting people in, your minutes should have that as well. Jeff, I'll just stop for a second there. I don't know, are there any questions about executive sessions? Sometimes there are. Do you see any?
I don't see anyone, but if anyone has questions, direct them to, because my name's not up there, I just realized, Town of Fairfield, or you can just send it to everybody and just say you have a question. I don't see any yet.
Okay.
Yep, so you can proceed.
So I will soldier on. So executive session is one path that boards and commissions can use. The legislature tried to create something of a balance. It's one avenue that boards and commissions have to exclude the public. And the other one's kind of funny. Well, it's funny in a FOI wonky sort of way. When I read you the definition of meeting, the sentence that follows that in the law says meeting does not include. Meeting does not include. There follows a list of things, many of which, if not all of which, everybody in this session would say, geez, that sounds like a meeting. What do they mean, meeting does not include? Well, what they mean is, or what the legislature was telling us is, well, you can call it a meeting if you want, but for the purposes of freedom of information, it's not a meeting. Which means not notice, not open, no minutes. At the top of the list is collective bargaining. Now, I know many, many boards go into executive session for collective bargaining, and it's just not the case. It's not a meeting. So not only is it not an executive session, it's something that, you can drive to the neighboring town. You can go to New York City if you want, and you have the collective bargaining sessions there. If you've ever been on a board, a volunteer board where collective bargaining is involved, and as a Board of Education member, I certainly was, hour after hour, negotiating little percentage points for this, that, and the other thing, critical to the financial future of your town. But nobody knew they knew what was going on at some point, but it was not done publicly. Nobody knew, because collective bargaining strategy negotiations are not meetings for the purposes of freedom of information. Another one would be executive level search committees. You're a police commission and your chief resigns. You form an executive level search committee to look for a new chief. That committee can operate outside of freedom of information. Not noticed, not open, no minutes. Now, if you think about that one kind of makes sense, because you're looking for the best possible candidates for this job. And in the process of looking for the best possible candidates, you might get people who are currently employed You don't want their current employers to know that they're looking for a new job. So that one kind of makes sense. And you're allowed to do that in private, secretly, as an executive level search committee. Just one word of caution. If you're ever in that sort of situation, make sure that you establish the executive level search committee. In theory, that commission looking for the new chief could be the entire police commission, but they have to name themselves as that search committee so that it doesn't look like they're having the police commission meeting sort of roll over into the search committee. You want to make sure that you're doing them separately, that when you're in that search mode, that's all you're doing. Another one in that list is the caucus. Now, some of you may be aware of that. The caucus says that members of the same board and the same party can talk. They can deliberate. They can talk about anything they want. Now you're saying, well, wait a minute. What if that caucus constitutes a quorum of the board? They could pretty much decide whatever they want to do. Well, we think that's one of those little gems that the legislators threw in there back in 1975, because we think that sort of helped get the law over the finish line. It is a giant loophole, but where people get hung up there is they forget that it is only same board, same party. So when the, when the town council meets and wants to bring the town manager in, so the Dems on the town council bring the town manager in, it's not a caucus anymore, they're having a meeting. It can only be same board, same party. So if you're going to use that caucus mode, make sure that it's just you and just people who are on your board. Another one that I get a chuckle out of, I'll read it to you. Any chance meeting or a social meeting, neither planned nor intended for the purpose of discussing matters relating to official business. When board members, you like each other, you want to go out to dinner, right? What else are you going to talk about? You know what I say, where do the best meetings in Connecticut take place? In the parking lot after the meeting. Am I right? Those of you who I see the heads going up and down. Am I right? Look, let's not be naive. Let's be realistic. These conversations take place all the time. What you have to be careful of, folks, is making those conversations go deeper, letting them go deeper than they should. Please avoid those deep, deliberative conversations in the parking lot, at dinner, that you should be having at the table. I guarantee you're really good about it. You're very careful about it. You all go out to dinner and you get into a passionate debate about a key budget item. I guarantee you the wrong person sitting in the next booth and files a complaint that you've had an illegal meeting. It never fails. So, use common sense. Stop short of having those deep conversations that you should be having at the table. Do not set your budget over the eggnog at the Christmas party. Be smart about it. Be smart about it, because these things and listen, we're all humans and we see each other. Well, we don't see each other much now, but in the good old days, we saw each other. You run into each other. Hey, what do you think about that? Yes, you can catch up on something. Yes, you can, get caught up on I missed the last meeting. You can have a discussion about the agendas. You can have those discussions, no problem. Just don't deliberate when you should, offline when you should be online. And along those lines, when I read the definition of a meeting, whether in person or by means of electronic equipment. Electronic equipment is one of the reasons that we're allowed to meet this way now during this pandemic, but it also allows board members, again, pre-pandemic, to phone in if they're out of town, something like that. But electronic equipment would cover a lot more than that. Think of your telephone, think of emails, think of texts. And how do we communicate today, especially today, because we don't see each other much? We start emailing each other. These email exchanges that go back and forth can be deadly as far as FOI violations. Be very careful the extent to which you go back and forth. Yes, I'm not telling you to stop using these devices, because that's how we have to communicate, almost by necessity. The chairman sends out something and says, look, folks, this is how I feel about this issue. I want you all to know this before the next meeting. Well, that's fine. But when somebody writes back and says, well, that's stupid, I disagree with that, we can't do that. And then somebody else jumps in and says, well, I agree with the chairman. And then the conversation snowballs. Then you've got a problem, because then, folks, you're having a meeting offline via email. People say, well, who's going to find out? Well, those emails become public records. Anytime you create something in the conduct of Fairfield's business, it's a public record by definition. Now, there are different exemptions that this may not be, that may not, but the bottom line is it's a public record. So if somebody wants to see any and all emails between members of, the RTM on topic X, if you've had a lengthy conversation via email, you'd have to turn those over, and then it could reveal that perhaps you've had an improper meeting. Be smart to the extent to which you use emailing and texting. And yes, you need to communicate with each other, but be smart that you don't, again, have the conversations that you should be having at your meetings. That could be that could put you in a situation where you get a complaint and you'd have a hard time, talking your way out of it. The last thing that we'll talk about with meetings is minutes. Minutes, my advice to people who have minutes is that they need not be the recreation of War and Peace. They are not every word that everybody says. They are not verbatim transcripts. I suspect there's some, poor unfortunate souls who take minutes sitting out here with me. I feel your pain. I do the FOI commission meeting minutes twice a month. You want a crisp, clear, concise recapitulation of what happened, but they are not verbatim transcripts. They are not he said, she said that. And what happens, of course, when you try to do that is at the next meeting, it's like, did I really say that? I didn't really mean to say that. Can we change it? I sound dumb. Can we fix that? No, that's why you stay away from that. Technically, the only requirement for minutes is a record of who votes for what or for whom. Now, if you want more than that, and I think you will, to create your town's historical record, you put it in there, but again, concise, crisp, not rambling verbatim transcripts, because that's only a recipe for disaster. Just again, as an aside, in this pandemic world, when we have a situation with, these recordings that you have to have, people have called up and said, well, recordings, then we don't have to do minutes. False. The minutes are still required. The recordings are a result of allowing us to meet virtually like this, but you still need to create minutes. And the minutes need to be available in 7 days. And by available, they mean in your office and the town clerk's office, just so that people can get them and see what happened at the meeting.
Tom, there are two questions, if you don't mind.
Good. Yes, good point for that. Yeah.
Okay, so the first question is, what remedy can be applied if a subcommittee meets improperly?
Well, we are not the FOI FBI. Somebody would have to file a complaint and say that this subcommittee met improperly, and the FOI commission would have to rule that the meeting was improper. That was FOI commission would rule it was legal. Somebody could call us and we could tell them that, but if you want an official stamp on it, it would have to go through the complaint process. Jeff, as an aside, what happens a lot of times with subcommittees, and this gets dicey. So you've got, let's say, a 10-member board, and there's a 4-member subcommittee, and then 3 or 4 of the members of the board who are not on the subcommittee go to the meeting and want to participate. Don't do that, because technically that subcommittee is an entirely different board, even though they're working on the same, under the same umbrella. And with those 4 join in with a subcommittee, then you've got an improper board meeting, not a subcommittee meeting. So always be careful the extent to which you allow your fellow board members to be a part of your subcommittee. But as far as, what's the remedy? Someone would have to file a complaint.
Okay. Second of 3 questions. I might as well do this trifecta now.
Sure.
Do you recommend that personal emails not be used?
In a perfect world, the answer to that question is yes. The reality is, though, that I don't know about your town, but mine just didn't have the capacity to give us all town email addresses. That would be the best way to do it. So yes, because you get your personal stuff, sort of blended with work stuff or town stuff, and that could become problematic for you, not for anybody else.
Right.
If you are going to use your personal account, my strongest advice would be to create a separate folder, or maybe have a separate email address on your I don't know how, however you're comfortable with it, so that you can at least segregate the town stuff and you're not having to search through everything if somebody asks for it.
Okay. Couple questions still popping up, and we'll do a couple more now and allow you to proceed. Is there a reason or requirement for verbatim transcripts?
No, there's none. That's the whole point. There's no reason for it at all. I mean, technically, you could have minutes that just reflect, who voted for what or for whom. Now, I should put an asterisk on that. In this, pandemic situation that we're in now, the law says that if you don't record, you would create a transcript off of it, or you don't want to make the recording available, you'd have to create a transcript, but that's only temporary. Otherwise, there's no requirement there. Land use boards sometimes want verbatim transcripts, but that's not really part of FOI. They want it because, they may have a controversial application that they're working on and they may get taken to court.
Okay.
But not required.
Okay. Here's another. Can several members of a commission either do a site visit or engage in a conference call with a third party for the purpose of gathering information without being deemed a meeting?
Technically, no. The site visit should be noticed. Site walks for inland wetlands, planning and zoning should be noticed as meetings and conducted accordingly. The conference call gets a little trickier if it's less than a quorum and it's just a couple of them just sort of gathering intel. That probably would be okay, but I would tell those people to be extremely careful how deep they went into board business.
Okay. And we'll go one more here. There's a couple more here, but is there ever a situation where the violation of these rules by a board can become a criminal issue, or a board member personally liable for the actions of the board or the action of the board action?
We can't say who writes the check, Jeff, but the FOI Commission has the ability to fine an individual who's violated the law anywhere from $20 to $1,000. I will be candid, it doesn't happen that often. Our board tends not to be punitive, but it is in the law, and I have seen it happen a few times in my 20 years. So the answer to that would be yes. A bigger problem for a board could be that if the violation of the meetings provisions are egregious, our commission could declare null and void everything that happened at that meeting and send them back to the drawing board. That's a bigger sort of Damocles that's hanging.
Okay. Okay. I'm going to ask one more question and then allow you to proceed. We'll save some.
Okay.
What happens if you are involved or invited to a meeting by a non-town group, but as a town board member, i.e. a neighborhood association vocalizing concerns?
Perfectly okay. It's perfectly okay to interact with your fellow citizens, townspeople. That's not an issue.
Okay.
Perfectly okay. And no need to notice anything or, put up any banners or anything like that. That's fine.
Okay. That's it for questions. I'll allow you to proceed.
Okay. So I just wanted to spend a couple minutes, folks, on public records. And what you need to know is that when you read the definitions of public records in the FOI Act, it basically says that every record created by every public agency in the state of Connecticut is defined as a public record. And in theory, anybody can ask to get a copy of it or can ask to inspect it. Now, if it were that simple, the whole records spiel that I give when I'm on the road, I can throw it out. But what makes the records piece difficult is that there are these different exemptions and exceptions, and people say, well, I shouldn't, and you don't know. So you have to have some sense or have somebody who has some sense to know, what the different exemptions are. But it's important, those of you who are not employees, who are volunteers, it's important that you understand that when you write that email to a fellow board member, that it's technically a public record. Somebody could ask to see it. When you send that, the email off to other board members, it's potentially a public record. Or when somebody gives you a letter and wants you to read it, and you read it at a meeting, well, that becomes a public record too. When you read the definition, I'll just read you a piece of it. It says, any recorded data or information relating to the conduct of the public's business prepared, owned, used, received, or retained by a public agency or to which a public agency is entitled to receive a copy by law or contract, whether that data be handwritten, typed, tape recorded, printed, photostated, photographed, or recorded by any other method. So you get the idea. One of the problems that I've seen in the time that I've been at the FOI Commission, just to sort of round it out, is that people have started, and now I should preface this by saying, I know that Fairfield's a really nice town and everybody gets along, right? You guys don't have political fights or anything like that. I'm looking, everybody gets along really well. But in some towns, people have taken to using this law as a weapon, as a means of getting back at people. And we don't encourage that. We discourage that. This law is about making sure that people have the information they need to make the decisions they need when it comes time to vote, when it comes time to, talk about a budget. But the reality is that people have done that. So if you ever get an FOI request and you think, oh my God, what do they want this for? Well, the first thing to remember is that technically you don't ask what they want it for. If they're asking for public records, you don't say, oh, it's him again or it's her again. You say, okay, blinders on, it's a public record, and then I have to figure out whether it's exempt or not. Now, this is the point where we start going through them, which we're not going to do tonight, the different exemptions. Just be advised that you can always call and ask. And I know you've got good people in town hall, your town clerk, the selectman's office, people like that can help you. Or, if land use, I'm sure I've spoken to people in town who know what they're doing. They know what some of these exemptions are, and they know to call us for advice otherwise. But just, if you ever get a request for records from anybody, someone who's difficult, someone who's not difficult, always make sure that there is some sort of a response issued in 4 business days. All right, what response doesn't necessarily mean to produce or generate the records. It means we've received your FOI request, we're looking into it. But if you don't respond in those 4 business days, the law says that you've denied that access, and the person can file one of those complaints that we were talking about with the FOI Commission saying, the chairman of P&Z has denied me access to these records, even if you had every intention of producing them, but you didn't respond. So the law says if you don't get that response out within 4 days, you've denied access, and you don't want to do that. The question was asked about personal emails. Does that mean that they're going to come in and they're going to grab my laptop or my desktop or my tablet? No. But what it means is that if you've got Fairfield emails, Fairfield business on those devices, that you'd have to extricate those particular records from there should somebody make a request for those, which is why we sort of urge you to curb as much as possible the use of your personal devices. I'm dealing with a case not too far from you in New Canaan, and let's see if I could be diplomatic here. The requesters are, shall we say, on the difficult side, and they've asked for all these emails and all these things, and they've got 3 or 4 really elderly, people who just really don't use, but they're searching their personal devices and they're confused and they're trying to find these emails. So they get their emails out, and then they find that the chairman had been using his work email account at a big New York company. I don't remember the name. And they had to go to the IT people at this guy's company to get those emails extracted. And can you imagine this massive company having to stop what it's doing and get these emails out? Now, the company could have said no, but the company was nice because they knew that the guy was sort of in a bind. And I mean, just think about, I hope he had the thought afterwards that maybe using his work email address was not the best idea that he could come up with, right? So, just think about, don't think automatically, well, no one's going to see this, or I can't imagine that this record would be one that's available to the general public, because it just might be. That's the point. You want to just make sure that you're under control when you use your devices and not putting yourself in an awkward position. I'll share a little story. I took a phone call a couple of months ago now from a woman. She says, "Hi, my name is Sean." I said, "Hi, Sean. How are you?" She said, "Good." She said, "I'm calling you from Georgia." Georgia. who's calling Connecticut FOI from Georgia? She says, yeah, my husband is an out-of-state contractor, and he had a job in Connecticut last summer. And I think he had an affair with a state worker. Why is she calling me? I had nothing to do with it. Why is she calling me? Well, she's calling me because she wants to see that state worker's emails, texts, phone bills. So if she's got an email that says something like, meet me at the construction trailer at 6 o'clock, we will review the blueprints for the project. And then, dot, dot, dot. That's a public record. She said, good, it'll help me with my divorce. Think before you write, think before you send, because you just don't want to see it, on the front page of the, see Connecticut Post or whoever covers you. I don't even know anymore, but just be smart about the extent to which you use email and things like that, and understand that everything you have is a public record that could be subject to disclosure. And Jeff, I'm looking at the clock. I'll stop there. We can maybe finish up with the questions before you jump into Roberts.
No, it's great, Tom. There is a question, and it's maybe a good wrap-up question too, is what is the best way to contact your office, and are you only available during business hours?
Well, that's secret. No, that's not true.
FOI.
We dial the main number, which is 860-566-5682. Now, again, it's a little funky. For instance, today I was at home, and every 10, 15 minutes, I'll go and retrieve the calls. If I'm there, I'll answer them right away. I can guarantee you that 99% of the people who call get call back that day, because I believe in that. I mean, that people need that. You could also email me a question. My email address is Thomas, THOMAS, .Hennick, HENNICK, @ct.gov. Now, during regular hours is pretty much it. But from that 8 to 5 range, you will get contact before the day is out, unless I'm not working that day.
Well, I will say you do call people back, because I called you yesterday. You called me within half an hour. So,
All right.
Let's see. I have another question here. For groups that have to put together a plan that requires commission input, does all of the drafting of the document have to be at regular meetings in public?
So you've got like a group that's putting together a document. I would argue that some of the work preliminarily could be done outside of the public eye. These sort of farm it out to different individuals and then put it all together, and then the final copies should be produced at the meeting. I would think that would be a more efficient way to do it.
Okay. Drew, I think you have a question. I'm trying to look for it in the chat. I can't find it. You can unmute yourself and ask if you want.
Yeah, thanks. I was just wondering, how long is the town required to keep the records and now the recordings on file? I know we've had issues with storing stuff in the past.
I'm smiling because that's not a question that I'm equipped to answer, because freedom of information doesn't speak at all to retention. I'm being flipped, but there's a set of retention laws in Connecticut that are administered by the Public Records Administrator. They're housed in the state library, and they will tell you specifically how long to keep which records. Now, when specifically to these recordings that we're all required to make, since last March, their advice so far has been to follow the requirements for land use recordings, which is to retain them for at least a minimum of 6 months after the minutes for that meeting are approved. That's the advice that they're giving now. So if you had a meeting 7 months ago and the minutes were approved, you could dispose of it. That's what they're telling folks now. But I don't.
Thank you.
I can't speak to it officially because it's not in our law.
But if you're so you could write the email and then delete it and not run into anything because you're not required.
Well, no, because there are retention laws that say that you must keep them. Specifically, if it's something that must be kept, then you violated the retention laws. You haven't necessarily violated FOI, but you violated the retention laws in the state. It's a separate set of laws.
So getting rid of your inbox, if you're just, or whatever, you're cleaning out your emails, you still have to retain it.
If you know, that's why it's good to have some sense as to what, I mean, the email between board members about agenda items, you can get rid of those.
Sure.
But if it's something a little more substantive, you might want to hold on to it.
Okay. One other question, Tom, are communications between commission and board members and town employees public?
Yes, written communications are, yes.
Okay.
Is it your turn?
Well, I think that's it for, we have one more question. Jack, if you want to unmute.
Thanks, Jeff. Hey, Tom, this is Jack Pistani.
Hi, Jack.
With Suzanne. How are you?
Good.
I just had a quick question. I know you talked about executive session. My understanding, and it sounded like from what you said, I could have been wrong, but are notes taken or minutes recorded at an executive session? Is that, and are they then part of the public record?
Great question. There are no minutes of the executive session. There are minutes of the meeting that reflect, you know, when the board goes in, who went in, what the topic was. Then the meeting minutes reflect when they came out and any action that they took. But there are no minutes of what happens inside the executive session. Because if you did create them, Jack, they would become public records, and that would defeat the purpose of the executive session.
Right. Okay, very good.
Good.
Thank you.
Thanks, Tom.
You're welcome.
Tom, I think that's it for questions.
All right.
Thank you.
I'll hang around.
Yeah, you're welcome to.
Okay.
There is another question on setting the agenda, the staff or the commission, and I'm certainly going to address that as well. But Tom, go ahead in terms of setting the agenda, the staff or the commission.
Who should do it? That's not anything that's covered, if you will, by the FOI Act. That would be entirely up to the town, however you wanted to do it. Our law would not dictate who sets the agenda.
Okay. All right. Now, can you see the PowerPoint presentation I have up? It's up? Okay, great. Tom, thanks again. Really appreciate that. And it's a great setting for kind of as we go into the Roberts rules now. So I'm going to use this presentation. I think everyone has received a copy or was sent earlier today. But if you haven't, then I'll be presenting it now and happy to send it by email. So here's a quote: "An organization that has no rules or governing documents to establish a course of action eventually finds itself in a state of anarchy." And if you think about that for a second, you wonder how is a meeting going to be run? And that's where Robert's Rules comes in. So going through this this document, I'll quickly take you through the history, parliamentary authority, bylaws, agendas. A lot of this was covered, and I'll skip through some of it that was. Taking minutes, most importantly, motions, debate and discussion, and voting, and then finishing up with maintaining order. So I'll cover each of these. It's a 20-something slide deck, but I'll go through it pretty quickly, but hopefully it'll be understandable. And if you have questions, what I might do is save questions for the end, if you wouldn't mind. Might be easier. Just trying to think. So I've got a couple screens going. It would just be easier that way if we do that. But let me go ahead and go through some of this now. So Robert's Rules is the most widely used manual of parliamentary authority in the US. And basically, parliamentary procedure itself is the name given to the tradition of rules of conduct and custom grown up in the civilized world to run meetings of a diverse range of organizations. And this can be clubs, church groups, private clubs, homeowner associations, boat clubs, professional societies, boards, unions, commissions, and other political bodies. So it really can apply to many different groups, most groups. Now, the history is that the lineage can actually go as far back as the Greeks, but its basic content was formed through centuries of trial and error in the English Parliament. And the rules are named, not surprisingly, by a guy named Henry M. Robert, who was a distinguished engineer, brigadier general in the US Army. He was a self-taught, active student. And he attended many meetings in his day and wanted to adapt the rules and practices of Congress to the needs of non-legislative societies. So as a major, in 1876, he created Robert's Rules of Order, and it became the standard authoritative guide on how meetings would be run. And it's now the most common form of parliamentary procedure in the United States and is used at meetings of all sizes, as I mentioned, including the United Nations. He started, the book was originally 50 pages in length. He wrote the first edition, as I said, in 1876, and then went to 176 pages, over 135 years and different evolutions of the book with new procedures and rules added, as well as revisions in 1915 and 1970. The manual has grown now to, I just looked, the latest edition, 649 pages in its current and 12th edition, which was published just last year in 2020. Previous edition was 2011. Now, it is said that 80% of the content will be used less than 20% of the time. So really, you don't need to know all of it, and that's why they have books, and I'll show you when I show you full screen, like this one, which is a book called Robert's Rules of Order, newly revised in brief, because that really goes through the core material that you need, and that itself is about 150 pages. So you really don't need to know all of it, but we'll go through some of the key parts today. Let's see. So parliamentary procedure and parliamentary authority. Parliamentary procedure is again the time-tested method of conducting business at meetings and public gatherings that can be adapted to fit any of the organizations I mentioned. And it allows members to take care of business efficiently, fairly, and allowing order while that's happening. So the current edition it just came out in 2020, and they always add little bits and pieces to it. And that's the book of rules, or the parliamentary authority. So every organization has its parliamentary authority. It's sort of rule book, and that allows, it shows basically members how to run meetings, the tenets of a meeting. So again, this presentation is going to go over the key procedures that are important to running meetings. And as I mentioned, it's all about allowing meetings to be run smoothly, allowing things to be done fairly, and doing so even when issues are contested. And it's not just when problems arise, but it's just a matter of course of business and course of a meeting to work well, to have this parliamentary authority and procedure. Before learning the specific rules, which we'll go through, members essentially need to know the core principles, and I have them listed here, and they are as follows. You want to conduct business one item at a time, to limit discussion to just that topic. And that allows you to keep focused on specific issues once at a time, or one time only, without jumping from topic to topic. Otherwise, it can get confusing. It can delay progress on items, but you focus on one item at a time is the key part. It ensures justice, courtesy, impartiality, and equality for all. So everyone is the same, whether you're a majority leader, minority leader, member, commission chair, committee chair, every member is equal in speaking at a meeting. At the same time, the majority rules, but the rights of the individual, the minority, and even absent members are protected. And these, again, are goals of Robert's Rules. As well, to ensure motions are in order, so no one can just speak up and say things whenever they want, but there's actually a process and a procedure for how you conduct a meeting and speak at a meeting and debate things and discuss and vote on items. And that goes into the next one, which is to have members obtain the floor properly and to speak clearly and concisely. And again, this eliminates crosstalk, requires speakers to address the chair, the president, or the moderator, and helps everyone. It helps the chair keep control and allows everyone to hear the business at hand. Also, it lets committees do their work. So sometimes, especially larger bodies, have committees, and the committees are often the groups that do the more detailed work. So the committees then can report up to the larger body. And then lastly, cutting off discussion when it becomes redundant. And so for controversial issues, sometimes you can even set a time limit. When discussion becomes circular, it's important to summarize the point, move on. When someone gets up to speak, to make sure it's not saying the same thing over and over and over. Otherwise, the chair can cut them off and move on. And so how strictly an organization really adheres to Robert's rules is up to that organization. But each group needs to follow at least the basics of parliamentary procedure, and then everyone essentially wins. Now, bylaws, and again, some of this Tom has mentioned. I'll just go maybe into a bit more detail or look at it through another lens. And a lot of times through this presentation tonight, I'll use the RTM as an example body. I mean, I think we have 25 or 30 RTM members. So I'll use the RTM as a sample body as we go through some of the motions and other issues here. So bylaws, the bylaws are essentially the constitution of an organization, and they exist in a written document that defines the purpose of a group, as well as its structure, its membership, how it operates, the rules given to that group. And there are usually certain things that are customized for an organization that are very, very specific to its work, to its makeup, and therefore it needs to have its own bylaws. And they will also state what parliamentary authority will be used. And as I mentioned, usually it's the Roberts Rules of Order. The Fairfield RTM has the rules to regulate. The RTM rules to regulate are the bylaws of that body. And in Rule 35 of that body, it says, quote, "The rules of parliamentary practice found in the latest edition of General Roberts Rules of Order shall govern procedures and protocol of the meeting, except as otherwise specifically provided by any rules or FOIA now governing the conduct of the RTM." So that's essentially bylaws. And I would think all of the organizations and commissions and boards that each of you are on, and there are many, would have its own bylaws. Another, term to understand here is quorum. Quorum is the minimum number of members required to conduct business at a meeting. And this is also usually stated in the bylaws. For the RTM, 40 members, a quorum is 21. So if a quorum is not indicated in the bylaws, by default, Robert's Rules of Order sets it as a majority of members. Again, 10 members, 6 is a quorum, 15 members, 8 is a quorum. When no quorum is present, then the meeting is limited to setting the time and place for another meeting and discussion of a topic. They can't vote, no substantive action can take place if there's not a quorum. Also, if members leave during a meeting, they have to duck out, whether it's to go to the bathroom, make a phone call, do something, and it drops below a quorum, then that body is restricted to just debating and discussing, but not voting. And so it is important to note to whether it's the town clerk or secretary, and this is usually when it's in person, obviously. You want to mention that, hey, I'm leaving, I'll be right back, just so they know. Now, we did talk about membership before and caucus membership, but the RTM has additional members in that they're ex officio members, in addition to the 40. They don't count towards a vote. They can't make motions. I'm sorry, let me repeat that. They don't count towards the quorum. They can't vote, but they can make motions, and they can second motions. They just cannot second motions by another ex officio member. They can't vote. So they can only second a motion made by a member. Now, the ex officio members of the RTM are all members of the Board of Selectmen, all members of the Board of Finance, the chairman of the Board of Education, the town attorney and assistant town attorney, and the town clerk. But again, each bylaw of each organization will establish the membership of that group and whether there are ex officio members. The agenda we talked about, specific list of items to be discussed at a meeting provided in the sequence. There's common parliamentary law over the years that has arrived at an accepted order at a meeting. Sometimes an organization may want to switch items that are relevant to that organization's business. Now, it is in this I think will coordinate with what Tom talked about, but it's generally wrong to assume that the president or chair sets the agenda, although it is common for the president to prepare one. Most organizations, unless a specific procedure is stated in the bylaws, an agenda is normally non-binding until it is adopted by a majority vote of the assembly at the beginning of the meeting. So at the time that an agenda is presented for adoption at the beginning, it is in order for any member to move to amend the proposed agenda by adding an item that the member deserves to add or proposing to a change. Now, as Tom did mention, once it is adopted, it takes 2/3 vote to change the agenda and add to the agenda. And sort of referring to the RTM again, it has a very specific process. So the agenda is set once it comes before the body because it has to go through, excuse me, a process through the town clerk. A 14-day period before meeting takes place, has to go out to the public 5 days before. So it has a specific process in its bylaws of how an agenda is set. So that doesn't fall into the world of, okay, we can redo it at the beginning of a meeting. But unless there is it's stated in a bylaw, essentially an agenda is approved at the beginning of a meeting through a majority vote. This right here is a sample of the RTM's general agenda outline, and it follows most organizations' outlines. Roll call, pledge of allegiance, approval of the minutes. Oftentimes there's honorary resolutions, a consent calendar for the RTM where all items are approved unanimously in committee and they're put together in one motion, one item to vote on. And then you have the business of what is called, at least in the RTM, the warning. That's the title for the agenda that we use. And that's the business of the day. After that, there's old business that can carry over from previous meetings, maybe something that was postponed. Committee reports, new business, and this is where we talked about how to add new business. And through a 2/3 vote at a meeting, you can add new business. So that can take place. And then you have announcements followed by adjournment. Now, other items that organizations may add may include even a prayer at the beginning, a guest speaker. Oftentimes, everyone has a guest speaker. Meetings have guest speakers at the beginning, or you may have a report from officers, treasurer, or standing committees or boards. So it can vary. We talked about minutes of the meeting. Let me see here. The minutes, again, permanent record. Tom mentioned this, usually taken by the group secretary. Include the main details are date, time, location, whether a quorum was present, who was at the meeting, and who the presiding officer was. Now, specific motions and their outcomes are also included, just not the exact vote counts, or they don't have to be. And discussion is not documented in the minutes. So essentially minutes are what was done, not what was said. Excuse me. And then they're presented for approval at the end of, at the next assembly's meeting. Moving on. Let me see here. Let me see if I can expand this. See if they're, well, I'm going to still leave the questions at the end because I don't think I can access the questions right now. So just write down your questions and I'm happy to address them at the end. Going through motions, let me just back up a second. A motion is a formal way to propose something. So this is how you get your business started. They're voted on by the entire group that is present. And it's really the way to resolve a dispute, discuss an item, disagree, and lead to a vote. Now, there are different types of motions. The main ones that are used are the main motions and resolutions. So this is basically the main item that you're going to be discussing and debating. So it's just the main. I make a motion to approve $50,000 in financing for this. That's a main motion. And then there are subsidiary motions. These are motions to sort of dispose of that main question. Okay, what are we going to do with it? What else do we need to do to the item at hand? And it replaces the main motion and becomes the immediately pending motion. And some examples are to lay some. I'll go through these as well briefly. To lay on the table, call the previous question. Many of these I'm sure you've heard. Limit or extend debate, postpone to a definite time, refer, commit, amending a motion or amending an amendment, and then postponing indefinitely. You then have privileged motions. And privileged motions, these are more when there's something urgent or special that has to come up, like simply adjourning or recessing. So they're privileged, and they have the highest precedence except for incidental, which I'm going to go through right now. Sorry, I'll drink a glass of water in a moment. The incidental motions are basically to provide a means of questioning the procedure, and concerning motions, and they some of these will include, I list them here: point of order, parliamentary inquiry, point of information, appealing decision of the chair, suspending the rules, object to consideration, and division of a question. So they're providing a way to question something and question procedure primarily. Let's see. Moving on here. Oops. So just going into a couple of these motions here, I'll go through them briefly and really go through the ones that are relevant. The subsidiary motions here, and a lot of this RTM members will encounter. Maybe all boards and commissions won't, but I'll just go through it because they're all important in various ways. Calling the previous question, and I put the type of vote that's required, and I'll go through the voting after this part. But calling the previous question, this motion closes debate on a subject and moves immediately to a vote. So it is non-debatable. So basically, it's used when conversation is just going on and on and on, and people just don't stop, and more people chime in, and everyone wants to get this to a vote because it could go on forever. Now, someone can make a motion to call the question. So that's like, we're going to stop discussion and debate. We're going to go right to a vote. So because that's stopping or changing something, that requires a 2/3 vote. Now, in the RTM, that can only be done after the public speaks. We're not really doing public speaking now with the Zoom or WebEx. It's a little difficult to do that. But in person, public would speak. Then once the public is done speaking, we can go back. Anyone can make a motion to call the previous question. That goes straight to a vote. Postponing to a certain date or time, majority vote. This is again, if the body just wants to push off an issue because it's not thoroughly vetted and just not ready, it's not urgent, then someone can make a motion to postpone to a certain time or day. Now, in doing that, or they need more information, you can do this to a certain date or time. However, items cannot be postponed beyond the next meeting. So it's really, you don't have a lot of choice, but you can postpone them to the next meeting, assuming they're not beyond 3 months from now. So it's either 3 months or the next meeting. Tabling a motion. This is if more at the beginning of a meeting, if a discussion has come up and it's just not as important, or members aren't ready to really deal with it right now, it can actually be tabled to the end of the meeting so other matters can be taken up, or you can table it to the next meeting. And it can only be tabled to the next meeting because it has to be taken from the table at that next meeting. So when someone tables it, if the session occurs within a 3-month period, if it doesn't happen the next meeting or after a 3-month period, the motion dies. That's it. And you have to take it again from the table to discuss it once again. Subsidiary motions. Let me just make sure. Give me 1 second here. Okay. So subsidiary motions continued, committing or referring. This doesn't happen much. I just put it on here. It's if you want to make a motion and refer it to a committee for further discussion. Now these two here, reconsider and rescind, are important for all bodies. And this is why. A reconsider is a motion that has been adopted or defeated during a meeting, and then one member who voted on the winning side actually wants to reconsider it. They're kind of having second thoughts about it. They're not sure. No, I want to have this looked at again and discussed again. They can make a motion, or someone on the winning side can make a motion to reconsider. And it can only be made by a member who voted on the winning side, but it can be seconded by any member. And it has to be made that day, the day the vote was taken. So it's something where, again, you have second thoughts during the course of the meeting. Maybe it's a 5-hour meeting and you're sitting around and 5 hours later, so, you know, I actually want to reconsider that vote we had, that discussion. So that can happen. Now, once that meeting's over, there's another recourse you can take, and that's rescind. This takes 2/3 of a 2/3 vote or a majority of the membership. That's because it's a little harder. This is, you know, the meeting's over. To bring this back, well, it should require a higher threshold to bring back. So any member can make a motion to rescind, essentially reversing the outcome of a vote. There's no time limit. You can make a motion any time. It does require a 2/3 vote or a majority of the entire membership. And I'll go over voting in a bit. Unless, and there's some qualifications, unless intent was made at a previous meeting or written, I have it written here, or you make a written notice ahead of time that you want to do this, then only a majority vote's required. So there's a couple stipulations, but there are recourses through reconsider at the meeting and rescind after the meeting's over, where you can actually bring a vote back or a discussion back for a vote. Let's see, amending an amendment, amending a motion. We all know, or have been through amendments. This is essentially making a motion to add something to an amendment, or even striking something from them. So it's inserting, striking, or replacing words, or even paragraphs to the existing motion. You can have an amendment to an amendment. But it's important. This is where it can get difficult, you know, for the moderator or chair to keep track of all the different amendments that might take place. Postponing indefinitely. This doesn't really happen, but it's a measure that can be used. This is if debate on a motion has begun and you want to get rid of that motion without a direct vote on it, and you can use this motion to essentially kill an item for the entire session. But until it's adopted, it's still left as the main motion. Now, there are other ways to do that. And finishing the subsidiary motions, you can limit or extend debate. Now, if you want debate, for example, excuse me, where you want to talk more about something than the rules may specify. You want to have someone talk 3 times, 4 times. You want to extend it to half hour. Or you want to say, okay, we're going to limit debate because we know it's going to be a debatable topic to 10 o'clock. It's going to be 1 hour. So you can actually make a motion to extend or limit debate on something in terms of number of times spoken, number of minutes somebody can speak, and then you know, when total discussion can end or continue among the body. Going to incidental motions, these are ones where essentially people can speak right out. And they're important because they're allowing someone to question procedure. So there's a point of order, and this is the most common one, really. You don't need to be recognized. There's no second necessary. There's no vote taken, but any member can stand up or call out a point of order, Mr. Chair, Ms. Moderator, Mr. President, whatever. You know, I think you know, there's been a violation. It's about a violation. I feel there's a violation of the rules. Something's not right. The chair then can appeal, well, then makes a decision and says, well, okay, I agree, or I don't agree. And if they don't agree, then further recourse can be taken from the body. It's called appealing the decision of the chair. So the body essentially has the final say after this. So what happens is someone, again, without being recognized, says, I'm appealing the chair. I don't agree with what you just said. And then this is going to go to the body. It goes to the body for a vote. But the first person who can speak is the chair. And then it can go to each member if each member wants to talk, but only once. And then it comes back to the chair to say final words, because this is the chair that's being challenged. So they have the right to speak first and last on this. And then it goes to the body for a vote. And it's a majority vote required to appeal the decision and go back to the ruling if the chair has changed the rule. You have parliamentary inquiry. This is just simply, you have a question on procedure. You're not challenging. You're not saying there's a violation. You're just like, look, it's technically a parliamentary inquiry. And you just say, look, I don't understand the rules, how the rules work here. And that happens frequently. I don't think people use the term parliamentary inquiry, but that's what it is. And then there's point of information. Point of information is when there's a question on the business, not on procedure or Robert's rules, but on the business at hand. So, I don't understand what part of the debate are we in now? What did someone just say? Just a little bit of a clarification. I'm going to drink some water here because I'm sure the cough is annoying. Let's see. As we move on here, we have suspending the rules. We talked about this. Basically, anytime you want to suspend the bylaws or suspend the rules of your body or the rules, Robert's Rules of Order, you must suspend anything. There's something called suspending the rules, where you want to do something forbidden, something different, something outside the scope of the rules. Someone makes a motion. If it's there are things, for example, the RTM cannot take on a new item after 11 o'clock, after 11:30, after 11 o'clock, and they cannot discuss an item past 11:30. Now, oftentimes that's not possible, especially when budget comes up. And so someone has to make a motion. I make a motion to suspend those rules because those rules are in the bylaws of the RTM. I'd make a motion to suspend those rules, allow us to talk as long as we need to. Because if that motion is not made and approved by the body, the RTM then has to come back the next day to finish business. So that's an example of suspending the rules. And then I put in here objection to a question. This isn't going to happen much. It's just, if there's a line of what's common, what's not, this would be further down the line. But you can actually object to consideration of a question before it even gets debated, right? When someone brings up a motion. You're going to get this material, this PowerPoint, and if you have any questions at the end, we can go over it. These are very specific motions that won't really be used much. I've, in fact, never seen this motion used, but I wanted to list it up here. Then there's a division of a question. So if there is a motion that has several parts to it that needs to be debated and considered and really voted on, someone can make a motion to just divide the item. No second is needed, but there has to be a vote. And I think there's been times we've forgotten, even when I was moderator, that there has to be a vote on if someone divides a question. Does not need to be a second, but simply the body has to agree. Yeah, let's look at things in pieces if we need to. So we go in now to making motions. We've all been there. We've all been part of organizations, and you're part of them now, where debate and discussion happens through making motions. But generally the process is, and this doesn't need to be, I don't need to spend more than a minute on this, but essentially obtaining the floor properly, letting the let's say the moderator recognize you, basically making your motion in a very clear and concise manner so everyone understands. And then waiting for someone to second your motion, because it's not going anywhere unless someone seconds it. No one seconds it, it just dies. So another member will second the motion, and then the moderator or the chair will restate the motion, just so everyone has heard that clearly. And then the body debates it and discusses it. The first person to be able to talk usually is the person who made the motion. That's just by tradition and proper etiquette. And then it goes to the rest of the body. And we'll talk in a moment about just speaking again. Then the question is put to the membership. Essentially, when all debate's done or someone goes to move the questions to go straight to a vote, then the question is put to the membership and it's voted on. And there's different ways to vote, which we'll talk about in a moment. Handling discussion. So right now, let's say someone's made a motion. Now it's about discussing and debating an item. Generally, Robert's rules, and probably most people don't know this, Robert's rule states that each member can speak for up to 10 minutes twice on each item, unless the bylaws state differently or a motion is made to limit speaking and the number of times someone can speak. So this goes back to extending or limiting debate. This would go hand in hand with that. So I speak to the RTM's rules to regulate. It's two people. I'm sorry, you can speak twice up to 10 minutes. And our bylaws, the RTM's bylaws, I believe, don't state anything differently, but you have to make a motion to change the amount of times you can speak on an item, and that's through extending or limiting debate. So if you want to speak 3 times, it's going to be a very debatable topic, and you want people to speak 3 times. Or quite the contrary, it's going to be too debatable. Everyone gets to speak once, and that's how we're going to do it. I'm going to limit it to two minutes per person, and that's going to allow for quicker debate and discussion, allow everyone to speak. But that still has to be voted on, unless the bylaws state that it is 2 minutes per person one time. And then in terms of preference or order of debate, the chairman or moderator must always recognize the speaker before the person can talk. So someone can't just blurt out, hey, I want to speak, or I have this to say. You have to be recognized. Otherwise, you're essentially out of order. And again, as I said, the maker of a motion generally is the first person to speak and address the item through debate and discussion. And also generally, if someone wants to speak a second time, the chair will want to allow everyone who hasn't spoken yet to speak first, and then can go for round 2. Also, if it's a larger group, and there's another way to do it is you can have make sure it goes Republican, Democrat. You can alternate if it's a pretty even group. There's different ways to do that, but the main thing is to allow everyone to speak once before you start going to a second person. That's the traditional way to do it. Has anyone else made a comment or asked a question that hasn't yet? Okay, now we can open it up to those who've already spoken. We mentioned staying germane to the subject, right? And this is something that I know the moderator and past moderators of the RTM have to watch carefully. With a big body, 40 people, used to be 50. It's critical for speakers to stay on topic. And that's one of the chair's main duties, is to sort of rein them in if they are going off topic. And it's solely the discretion of the moderator, the chair, to do that. But I think everyone gets a sense of when someone's going off on a tangent or telling a story or talking about their life, which may be related and may be important, and you give them a little time. But then you just know when it's going too far out. So it's being germane to the subject. Very important thing is debating issues, not personalities. We're not talking at each other. We're talking to each other, to the group. We're not talking at each other. We're not debating personalities and specific opinions. It's about the issue. And that's very important. And especially with all that's happening today too. It's very important. We're very in choosing our words and how we speak to others, and not becoming nasty and not being critical, not lashing out at anyone. It's very important to do that. This is a legislative body. We're either elected or appointed. We have to carry on as professionals. So it's important to know that, you got to discuss the issue, and you can disagree with the issue as much as you want, just not the person. And then essentially closing debate. Debate ends, discussion ends when there's nothing more. Everyone's done, or someone has moved the question or called the question, and we're ready for a vote. So, voting. There are essentially 4 ways to vote, or that people vote. It's by voice. So the chairman will ask all those in favor say aye, those opposed say nay, and generally just hearing that can give you enough sense if there's overwhelming support. But generally, if there's 10 people or 6 people, you go around the table and say aye, or yes, no, and it's that simple. It's just a voice vote. Then there's roll call, and again, this is probably more apropos for larger groups where you need it's going to be a real close vote, and it's not a 6-person body or 10-person or maybe not even 15. This is 40 to 50, like the RTM, where you need to have a roll call vote. So that's where the clerk, in the case of the RTM, will call everyone's name individually in order, and they'll say yes or no. Now, after that vote is done, after the roll call is done and everyone's voted, you cannot change your vote, by the way. Then there's general consent, and that's basically general consent, and by division is if there's enough overwhelming support, aye, and here 2 nay, then you'll come out and say, okay, who are the 2 people to oppose, and then you record them. It's pretty manageable. It's just the larger bodies, again, as Karen knows as a moderator, they can get a little tricky sometimes. Now this is an important section here. This is the votes that are required. So each motion requires a certain vote for it to pass. And again, all members have a right to vote. But the key votes are here. The majority of votes cast is how motions are approved. So this is abstention, which we'll go over in a moment. That's a non-vote. So if there's 100 members, 90 votes are cast because 10 people abstained. The majority is 46. If there are 61 abstentions, so there's 39 votes, 20 yes, 19 no, 61 abstentions. The motion passes because it's a majority of the votes cast. Those 61 abstentions are not cast votes. Then there's majority of those present. A little trickier, but a nuance to know. I'm going to drink a glass of water, and I apologize for this. This is slightly different. This requires a majority of those present. So it's more than half the attendees at a meeting. Using 100 members again, a motion passes if the 51 members vote in favor. Plain and simple. No matter how many abstain, how many say no, there's 100 people there. 51 people need to approve. Now, this is usually used if the bylaws state it. There's no specific motion or item that I'm aware of that requires a majority of those present, but it can be in bylaws. We then go to 2/3. Now, 2/3, you've seen this already in past motions. This is a really important required vote because it's used when you need to change something, to change the procedure, or you need to suspend something, or close or limit debate, or do something that alters the course of business. That requires a 2/3 of votes cast. Again, not 2/3 membership, not 2/3 of people present, but 2/3 of votes cast. And then lastly, there's majority of the entire membership. So this is only needed when amending something previously adopted, or to rescind an item previously adopted. Not frequently used, but there are occasions. I'm just bringing light to different types of votes. The most important thing is 2/3 vote, and then majority of votes cast. Now we are almost done here. Abstentions, very important. In parliamentary procedure, an abstention is a voter's decision not to vote. It is not a vote, and it is not counted as a vote. And so there are some scenarios when this can happen. You don't want anyone to know how you feel. And that can happen, whether it's political reasons, personal reasons. You just don't want anyone to know. You're ambivalent about the measure. You don't really care either way. Now, I think most of us who are elected officers, officials, members probably care about most things, I would think. And they'll probably have an opinion either way, enough so that you want to say yes or no to a vote. But that's one of the possible reasons. Maybe you're not sure what you think. You don't feel like you have enough information. You're not adequately informed. Maybe you didn't participate in any of the discussion. You don't feel that you're up to speed to vote, and you shouldn't vote. So that can happen. But most importantly, it's because of this fourth item. There's a real or perceived conflict of interest. There's a financial conflict of interest. You benefit somehow with your vote, or someone related to you benefits with your vote. And that's when you can actually say, I am going to recuse myself and abstain from this vote. And people will understand. And it's probably worthwhile when you do abstain, sometimes when you can say why, it's good. You don't have to. There's no requirement. But there are times, especially when there's a potential conflict of interest, it's fine to state it and let people know. But again, these are all personal choices. There can be political reasons for abstentions, vote counting, but it's usually personal choices. So again, using the example, 40-person RTM body, 20 yes votes, 19 no votes, 1 abstention. The item fails. The item fails because there weren't 21. The majority of the votes cast. And remember, a tie vote is also a failed motion. Finishing up here, and then I'll open it up to questions. And is maintaining order. This is we kind of referred to it through the presentation. This is the tough job of the moderator or the chairperson to maintain order, especially when it is live. And the members of the public can come sometimes. Budget time, it can be harrowing sometimes. So maintaining order is very important, and that is at the discretion of the chair. We've talked about calling people to order, calling people out of order, and setting limits or advising for people to move on if the topic's not germane, and keeping to topic. So that's very important. And if somebody violates those rules, the chair, the moderator, has every right to call that person out of order. And on the flip side, members themselves can call the chair out of order or contest something that may not always succeed, but they have the right to do that. And then lastly, adjournment, obviously, is what it states here. The session comes to an end, everything's done, all announcements are made, and someone makes a motion, must be seconded and voted on and approved by a majority to adjourn the meeting. And then it's over. Lastly, this is more for RTM members. They're just some rules that I think all of you should probably know if you don't already. And it's just a matter of reading the rules to regulate. Rule, I don't have to go over each of them, you probably know, but actually the rules in the RTM, and I should have known this and should have stated this earlier, it's not speaking twice. Members of the public may speak once, is what I'm trying to refer to. But they can only, they speak after the body debates, and then it goes to public. So the members speak once and only once on a public, I'm sorry, members of the public can speak once on an item, and that's it. And that usually is timed. I remember when I was moderator, I used to time very debatable subjects to 2 minutes or a minute and a half, so that flow could flow if the debate and discussion could happen. Consent calendar we talked about. No member can change the roll call vote. Majority and minority leader can call one 10-minute recess each. There's a procedure for ordinances in town. These are all in the rules to regulate in the bylaws, and it's very important to know them. And then just lastly, bring a copy of bylaws to your meetings, copy of Robert's rules if you can, list of the members and the committee members, and then the agenda and all supporting material. So I am going to right now, give me a second. I am going to stop sharing this and allow for questions. Okay, just give me a second here while I go through this. Let me do this. because maybe people didn't write any down or don't have any. But I'm just going to open it up right now. If anyone does have any questions, you've been trying to unmute you, but it's not working. If you have any questions, go ahead and unmute yourself. If you don't, that's fine as well. Has there been any updates on Robert's rules in regards to a virtual meeting? That's a great question. I haven't seen any, but I also haven't gone through the latest edition in depth. But that's a great question, and I'm going to look into that. And Marcy, I know you asked that, so I can get back to you on that. It's a great question. Yes, there is a one-page guide. So somebody asked, is there a one-page guide? There is. So the former great parliamentarian here in Fairfield was Carl Dickman, who was a state representative, and he was a real student and scholar and teacher and expert on Robert's rules, official parliamentarian, and he wrote a one-pager that was called Dickman's. Here, I have it right here. The traffic lights. And of course, I don't have a copy of it right here, but Dickman's traffic lights for rules to regulate. And he had all the main motions and whether or not you could, required a second or if it could be debated and what the required vote was. And it was great, a great piece. And that still exists. And I can actually share that with people. So something I can share if you haven't gotten is the PowerPoint. I also have a more detailed Word document with a lot of this that you can look at. And then, of course, there is this book, which is the Robert's Rules of Order, newly revised in brief, which I recommend for anyone who wants to get up to date on some of the rules and have a guide right there for them at any time. And it's really useful. The big book, if you want to look through 660 pages, go for it. But it's quite a bit. You really don't need all that. I think that is going to be it here. Let's see if I see anything else. Yes, Karen, thank you for saying Dickman's traffic lights for parliamentary procedure. And there's a link here in the chat section. I can also make sure that gets sent out to everybody. It's a very useful guide. Let's see. I'm trying to go through are the RTM bylaws in the town charter? The bylaws are a separate book, a separate sort of constitution. The charter, if I'm correct, may refer to the rules to regulate, but the rules themselves are in a separate book. Unless I missed something, I may have missed a question here. So if, let me just say, if anyone has any other questions, feel free to unmute yourself and ask it because I might have missed it in the chat section.
Hey, Jack, this is Jack Testani. Sorry, I've been trying to write it in the text. I just have a quick question on a point of order. Because does that have to be recognized by the chair? That's part A of my question. And then if not, part B, if the chair then says it's rejected or I don't agree or whatever, how does then sort of get it back to the body? Does the person who raised the point of order say, well, I'd like to get the body to vote on it? And my guess is the majority of the people aren't going to support a point of order if the chair isn't willing to entertain it.
That's right.
And the only other piece of that question I want to ask is, can the point of order be about anything, or does it have to be about something specific? Like if somebody is droning on endlessly, even though the 10 minutes hasn't expired, can you say point of order at that point?
Yeah, I mean, the point, again, the point of order is a violation of the rules. So one of the rules is to stay germane and not go off on a tangent. So yes, someone can make a point of order, and it can be just mentioned out of nowhere. It doesn't have to be seconded. The chair essentially has to recognize if you say point of order, that can't be ignored because it's an incidental motion. It takes precedence over every other motion. The motion being debated right then, a subsidiary motion, it is a motion that takes the floor right there, a point of order. That is the motion at hand. So it has to be, it's automatically acknowledged or recognized. Now, it's usually, again, a violation regarding the rules. And as I said, one of the rules is being germane and speaking within the topic. So that's on the edge of making a point of order. Now, how does that go to the body? You're right. Many of the body might not support that point of order. It has to go to the chair. The chair then will determine whether that makes sense. And I agree. Good point. I'll correct it. Or I don't agree. You're wrong. It's this. And then if anyone then says, well, I don't agree with that, we really have to go, we have to do something else instead. That's not the right process, or you're wrong about that. They can then appeal the chair. Once you appeal the chair, and that also is the motion at the time that takes precedence over everything else, it would then go to the body. So, but the moderator, the chair, gets to speak first and last, and every member gets to then speak as well. So, yeah, so that's the process. I mean, it has to be, essentially, it's only if the moderator or the chair or the president does not agree with that point of order. Right. And oftentimes it's just clarified. Like if a point of order, I think it should be this. Oh yeah, you're right. Yep. Let me go back and fix that. And it's as simple as that. But if it's, something deeper and more debatable, and the chair says, you're wrong, you're not right, but that person or someone else says, well, I think the chair is still wrong, then they can appeal it. I've seen it maybe once or twice in 15 years. Doesn't happen often because it's usually cleared up. If someone, point of order happens somewhat frequently, but it's cleared up usually right away. It's just, maybe it's a miscommunication or misunderstanding, and it's usually cleared up right then.
Okay. Thanks, Jeff.
Yeah.
Yep.
Jeff, this is Chris McCoy. Can you hear me?
Yes.
I'm Vice Chair of the Park and Rec Commission. How are you? Thank you. You were great.
Oh, thank you.
Which can get out of to end a meeting or to press down a meeting when public discussion gets a little bit out of hand.
Mm-hmm. Well, is it discussion again among the public with the members, or is it discussion among the members, or?
Yeah. Public
Okay.
discussion. So
Sure.
Marina example.
Right. Well, generally, at least with the RTM, members of the public are actually not allowed. They're not allowed to ask questions. I know that sounds crazy. They're allowed to make comments. It's a public comment period. It's not a public question period. So if a member of the public does ask a question, and a member would like to answer it, first of all, the moderator or chair would likely say, you can't ask a question. And then if a question, now that it's out there, if someone actually wanted to address it, they could. But the member of the public is sort of out of order in asking a question. They can make a comment. Now, in your board or your commission, I'm not sure if there are bylaws that state anything in terms of interaction with the public, but generally the public is there to observe and to make comments. They're there to speak. And that's how they get heard. And that's the beauty of that. Now, if they go to ask questions and a small group of 5 or 15 or 10 or whatever wants to answer it, they can. There's nothing to say they can't answer the question. They don't have to. It's a public comment period, and members of the public are allowed to witness and listen and be apprised and take in information and do research that way. But technically, their question doesn't have to be answered. So how do you limit that? I think you got to tell if you have a large public gathering at a meeting, I think you need to, as chair or vice chair, state ahead of time, this is how we're going to proceed today in terms of public discussion or comment. So you have to set that down, unless it's in your bylaws where something specifically states interaction with the public. So you got to state it ahead of time. And, you know, I've done it many times as moderator. I think parents had to do it. When you get those meetings and you get 50 to 200 people, who are there to speak. I mean, it's a lot, but you got to hear them all out. So maybe what you set it to 30 seconds, you send it to a minute. I literally used to have a stopwatch. I didn't like doing it, but I had to do it. I had a stopwatch. You go 60 seconds, go. It's terrible, but it's the only way to do it. And you can only speak once, and you can only make a statement, not ask something. So those are some things you could put in place if you feel that something's going to be very contentious going forward.
Hey, Jeff.
Yeah.
If I could jump in, this is Tom. There is a provision in the FOI Act that speaks to that as well. Chris, if you wanted to, sort of look at the Act, Section 1-232 says that you are allowed to, I'll just read it. In the event that any meeting of a public agency is interrupted by any person or group of persons so as to render the orderly conduct of such meeting unfeasible, an order cannot be restored by the removal of individuals who are willfully interrupting the meetings. So that, first of all, is the trigger that under FOI you could have them removed. The members of the agency conducting the meeting may order the meeting room cleared, and you can continue in session. Now that's an extreme. It doesn't happen that often, but if it's a unruly group under FOI, you're allowed to have the people removed, and if that doesn't work, you can clear the room.
Thank you, Tom.
I'm glad you mentioned that, Tom. I didn't want to state that, but you're right. The chair moderator has absolute authority to clear that person out if right. Necessary. Yep. And I am almost certain I had to do that once or twice during some very heated discussions 10 years ago, or whenever it was. I had to. Maybe it was 7 years ago. But it's happened. Yeah. Let me see if there's anything else. I don't see anything else here. I hope that was useful. We did record it, so there will be a recording on the town website. I got to figure out where. The traffic lights document will be available for people. And then I believe, again, this PowerPoint was sent out. If no one got it or if someone didn't get it, you're welcome to email me. My email is jrsteele, JRSTEELE, @optonline.net. And I'm happy to answer any questions or go through any of this. But I know it's a lot of material. I talked fast. Went through everything quickly, coughed a lot, and I apologize for that. But I hope some of it resonated and made sense, because really it's just understanding some of these key principles to running meetings and being part of meetings that are run well too, because the members themselves contribute. It's not just the chair, the moderator, the president. It has to be up to the members to help these meetings get run smoothly. And that's why there's a process in place. That's why there's rules in place, and to know them will help everyone. So all you chairs and vice chairs out there, know those rules in case you have to step in and run the meeting, because it's very important. And that's all there is to it. So if anyone has any other questions, thank you again. I'm so sorry I had to clear my throat so many times, but going on and on, we'll do it in the evening. But thank you everyone for joining.
And thanks for including me. Happy to be here.
Tom, thanks for joining. It was fantastic.
Okay.
Really, thank you. Okay, bye-bye.
Good night, everybody.